My name's Tim Spencer-Lane. I'm a lawyer from the Law Commission of England and Wales. I'm here to talk to you today about the new scheme that will hopefully form the basis of the replacement legislation for the Deprivation of Liberty safeguards. I'd love to start off my presentation today with some funny anecdotes about my time in Sheffield as a teenager. Unfortunately, there aren't any. I haven't been to Sheffield before, but it does look jolly nice. Right, I've got about half an hour. It isn't long to detail the new scheme. There's a lot in the consultation paper, and I've tried to sort of cherry pick the main elements and also recognise the important role that the safeguards could potentially play in palliative care and end-of-life care. I'll start off very quickly with the boring bits about the Law Commission. We're an independent body created by statute. Our job is to keep on to review all of the law of England and Wales, and as Neil has rightly said, it's the government's job to introduce legislation, but we make recommendations which the government must consider. And 2/3 of our reports get implemented in one form or another, and those that you'll be familiar with will include the Care Act, the Children Act, and the original Mental Capacity Act, which were all based on Law Commission projects. And we're currently on our 12th programme of law reform, which includes the review of the Deprivation of Liberty safeguards. So the consultation paper itself was published on the 7th of July. We are now in consultation mode. So we've got a 4-month period of public consultation where we're going up and down England and Wales, speaking to people like you, debating our proposals, talking to people about what they like, what they don't like, and what they want to consider further. And I must emphasise at this stage that although our proposals are very serious, we think they do provide for a new scheme that will be better than the DoLS. They are what they say on the tin. They are provisional proposals for reform of the law. Those of you who have participated in Law Commission consultations in the past will know that as a result of our consultation, we will change the vast majority of our recommendations. In some cases, we are prepared to change them substantively if people can make a good argument to us. So we do take consultation very seriously indeed, which is why I'm here today. Very quickly, the criticisms of the DoLS and why we think it needs to be replaced. Its length and complexity is huge, cumbersome, bureaucratic, very difficult even for lawyers to understand, let alone frontline practitioners who are very busy and frazzled. Scale of the problem, post-Cheshire West, 10-fold increases in applications. You're better aware of this than I am. The DoLS were basically designed to provide a large number of safeguards to a small number of people. That just isn't sustainable now, post-Cheshire West. Ill-suited and inadequate terminology, so everyone seems to hate all the terminology that's associated with the DoLS, like supervisory bodies and managing authorities, and in particular the title Deprivation of Liberty safeguards, which in some cases seems to even put people off using the safeguards. Now, if these were the only 3 problems with the DoLS, my job would be very easy indeed. I could streamline the DoLS, I could rename them, I could come up with all sorts of lovely new terms to make them work more efficiently. But the consultation paper concludes that there are much more fundamental problems with the DoLS that does mean they need to be replaced, and they are fundamentally flawed. Firstly is their narrow focus on the thing called deprivation of liberty under the European Convention on Human Rights. Few people seem to understand what a deprivation of liberty means when they see it, but probably more importantly, the DoLS don't have a lot to say about other things that people consider to be very important around their care and treatment. So things like a person's placement into a care home, unless it's a deprivation of liberty, isn't really addressed by the DoLS. So all the sorts of rights to family life under Article 8 aren't recognised, and we think that's basically wrong. The disconnect with the Mental Capacity Act, DoLS are seen as something different. They're an add-on. They're not sort of in tune with the empowering ethos of the Mental Capacity Act. They're seen as separate legislation. Local authority perceived conflicts of interests. So the DoLS assume that the local authority can conduct its safeguarding responsibilities, its commissioning responsibilities, and also sign off deprivations of liberty as well. And the judges have had big problems getting their heads around this and the sort of conflicts of interest that potentially arise as a result. Limited scope. So DoLS only apply to hospitals and care homes. They have very little to say about deprivations of liberty in other settings, particularly supported living, shared lives accommodation, where the assumption is that public authorities have to take the case directly to the Court of Protection in order to authorise any deprivation of liberty. The DoLS don't really do anything about that. A one-size-fits-all approach. So the DoLS treats a deprivation of liberty on an intensive care ward in exactly the same way as it would in a long-stay care home. That doesn't make sense to us. Finally, problems with oversight and safeguards. So disabled people tell us that it's very hard to challenge decision makers, and it's very hard to get to the ultimate decision maker and try to change things around. So that's also been a big concern of ours. So consequently, we're putting forward a new scheme for your deliberations today, which we've called protective care. So I'm not the world's most imaginative guy, so I simply nicked this from the Department of Health's original consultation on the Bournemouth safeguards. The title of it is up for grabs. In fact, the legislation doesn't have to use a title at all. DoLS isn't mentioned in the actual schedules to the Mental Capacity Act, but I think it's a good opportunity to give it a name and a label that people agree on, that people can rally around. I think that's an important aspect of it. In terms of how we've designed the new scheme, it's informed by a number of key principles. First and foremost, it must deliver and be seen to deliver improved outcomes. So the only way we're going to get buy-in from health and social care professionals, from disabled people, from carers and families, is for the new scheme to be able to deliver things for people, for it to benefit the person, to be able to provide very tangible benefits. So rather than having this rather esoteric conversation about what is and what isn't deprivation of liberty, the safeguards should be there to provide something which improves the person's condition. And in that way, we hope to get much more buy-in from care home staff, hospital staff, who will recognise, hopefully, that the new scheme can benefit the person. The scheme is based in the Mental Capacity Act. It's designed around people who lack capacity to consent to certain things. We think that's right. We think it's important to link the new scheme to the sort of principles of the Mental Capacity Act, which practitioners say are very important to their practice. But it also needs to be a non-elaborate system. So people need to be able to understand it, to make sense of it. That doesn't mean getting rid of people's important legal rights, but it does need to be streamlined. And part of that, I'm afraid, is the need to make cost efficiencies and save resources. This has also got to be part of our new scheme. We're not going to be able to deliver a new scheme unless we can argue that it's not going to be as costly as the DoLS system is at the moment. Non sequitur is that our new scheme has to be compliant with the European Convention on Human Rights, but what we're saying is that that's not just Article 5, that's also Article 8, the rights to family and private life, which we think are equally as important. And finally, we think that the new scheme should be as supportive as it can be of the UN Disability Convention, and we think there are a lot of important ideas that are contained in the Convention that potentially we've got the opportunity to consider further. And if I get time today, I'll identify some of those. So in terms of the remit of the new scheme, deprivation of liberty extends well beyond the paradigm examples of imprisonment, for example. So essentially, deprivation of liberty for the purposes of Article 5 can take place in any setting. If Article 5 is engaged, then the law requires safeguards to be provided. So that will include hospitals, palliative care, care homes, and even domestic and family settings. Now, what we're saying is that the new scheme should be broad in its remit, but it shouldn't treat every single setting in the same way. That safeguards should be tailored, they should be tapered according to the needs of the person in a particular setting. So what we're putting forward to you is almost a range of schemes that provide for different levels of safeguards which hopefully are meaningful to those working in the settings. And that's the key for us, to try and make them meaningful to the setting in which the detention is taking place. Now here's my fabulous diagram, which took me hours to do, to try and illustrate, encapsulate in a single slide what we're trying to do. What we want to do is take the focus away from Article 5 and this concept of deprivation of liberty. We want to front-load the system to have a preventative effect, to try and identify people who are vulnerable, who are becoming vulnerable. They may not be deprived of their liberty, but nonetheless, everyone agrees that they would benefit from some degree of oversight over their care and treatment, someone keeping an eye on them. Now that goes through a number of tiers, so once things start to become a little bit more serious, then we think additional safeguards should kick in. Now that's not at the moment designed around the concept of deprivation of liberty. We think we could design a scheme which are designed around other things, including restrictive care and treatment, which is put in place on a person's care plan. But the idea is that we get away from the focus on the deprivation of liberty, although this is still part of the picture, as it were. So the focus is on prevention. So basically, there are two systems that we're trying to put in place to try and encourage this sort of approach. The first we've called supportive care. So the idea of supportive care is that it's put in place for people who lack capacity to consent to their living arrangements and are being placed in or are already living in care homes, shared lives, and supported living accommodation. Now, we're not really trying to introduce new legal rights here, but we're trying to make sure that the existing law works better. So good social work practice, good nursing care practice, which should be in place, we're trying to confirm that that's happening on the ground and that people are getting the care and support arrangements that they should be getting in law. So when a person moves into one of these types of accommodation and they lack capacity to consent to moving in, then we think it's right that the placing body, the care provider, should be required to confirm that the relevant legal safeguards have been followed. So those safeguards might be those provided under the Care Act, they might be those provided under NHS continuing healthcare, or these people may be self-funders, where no public authority is involved in their care, in which case the care provider would be expected to put some sort of care plan into place, just to confirm that a proper mental capacity assessment has taken place and to confirm the person's care and treatment arrangements. There'll also be some level of oversight over the tenancy arrangements. Now, I'm not suggesting that local authorities or the NHS should start authorising tenancies. All we're saying is that the care plan needs to confirm on what basis that accommodation is being provided to the person who lacks capacity to consent to that accommodation. We've been rather concerned that too often it's left blank. Things haven't been said or agreed, and we'd at least expect some sort of confirmation on the person's care plan as to how that tenancy arose or whether the Mental Capacity Act has been used for that purpose. The local authority would also need to be satisfied that the right to care planning safeguards had been put in place under the Care Act or under NHS continuing healthcare. Doesn't mean they need to do anything different, but just to make sure that things are being reviewed, things are being overseen. And finally, rights to advocacy will continue to be central to the new scheme. So we're suggesting that all people under supportive care would become entitled to advocacy or an appropriate person under the Care Act. And we think in most cases, people should already be receiving advocacy, whether they get an IMCA, an IMHA, or a Care Act advocate. But it may be there are a small number of people at present who aren't entitled to an advocate, particularly self-funders, for example. So this would represent an extension in terms of legal rights in that respect. Now, once a person is in the accommodation or is moving into the accommodation and things are getting a little bit more serious, their care and treatment is becoming rather more intrusive, then a new system of safeguards would apply. And these, generally speaking, would be the direct replacement for the DoLS. So we've called it restrictive care and treatment. This would apply to people in care homes, supported living, or shared lives accommodation. It applies to such people if restrictive care and treatment is being proposed and the person lacks capacity to consent to that care and treatment. So the big issue is what restrictive care and treatment means. We're suggesting that it would be quite straightforward for the statute to define that by reference to a list, which provided examples of what we mean by restrictive care and treatment. Now, as you can see from the list, hopefully, restrictive care and treatment would include, but it's not limited to, deprivations of liberty. So someone who is deprived of liberty under the acid test would fall into restrictive care and treatment, but other people would, whose care arrangements don't amount to a deprivation of liberty. So the sorts of things we're suggesting could be included in the list include the use of seclusion, for example, restraints on the person, medication which is used with the intention of sedating the person, where the person objects to their care and treatment, even where significant restrictions are being placed over a person's contact diet and clothing. So these are the sorts of situations where we think some form of additional oversight is needed. Now, we're not talking about the same level of oversight in every single case as you get under the DoLS. This can be tailored according to the circumstances of the case, but we think these sorts of people are, by any ordinary understanding of the word, in need of some sort of level of oversight. And that's what we're trying to get at here. So in terms of our discussions today, be very interested in whatever you say, but if you are particularly concerned about restrictive care and treatment, I'll be very interested to know whether you think, A, the idea of a list is any good at all. It's the sort of thing that lawyers often come up with because we think it helps understanding, but it may be that it doesn't quite translate into practice. But if you're with us, if you think that lists are good things, are these the right things to include in the list? Have we missed things? Is it too extensive? Are there things that we could add into it? Could we reword some of this to make their meaning clearer? So we're very happy to engage at any level on that. So once you get into restrictive care, you get a number of safeguards. So your assessment, which enters you into restrictive care and treatment, must be overseen by a professional, a specific professional, which I'll come to in a moment. That professional doesn't have to do the assessment themselves, so they would have discretion about whether they take over the assessment in a sort of BIA way and have an independent assessment of that person's care and treatment, or maybe the BIA is happy with the person's care arrangements and is happy to delegate the assessment to the social worker or the nurse on the ground to allow them to do it, and maybe the BIA could act as a resource for the assessor to give them advice about applying the Mental Capacity Act or advice to friends and family or the person themselves about the process. So it's almost like a sort of safeguarding manager role where they're chairing a process rather than in every single case having to take over it. The independent professional would have powers to recommend conditions and make recommendations as well, which is very similar to how it would apply under the DoLS at the moment. There would also be ongoing care planning safeguards and monitoring and review of the person's care. We're quite concerned that it's being reported to us that too often the BIA will go in and place conditions on a person's care and nothing happens, and then the local authority comes back a few months or a year later and no one's been checking on it. So we think there is, or there could be, an ongoing checking role for the new professional over what's happening in terms of the person's care and treatment arrangements. Person themselves would have the right to appeal both to the local authority against their care and treatment arrangements, but also to a tribunal, not the Court of Protection. So we're suggesting that tribunals are much better suited to hear reviews of cases in these sorts of circumstances. They're less remote than the Court of Protection is. They can encourage the participation of the person who's subject to restrictive care and treatment, which is a fundamentally important aspect of our new scheme. But also, I guess, in the longer term, we think they can deliver a much higher level of cost efficiencies than the court can deliver at a large volume of cases. So we're suggesting that a tribunal could take over this jurisdiction. And finally, there would continue to be Rights to Care Act advocacy and an appropriate person, and also to a relevant person's representative, which would remain part of the scene, which we think that's quite an important recognition of the role of the family. Central to our new system is the notion of a new professional, which we've called the Approved Mental Capacity Professional. So we've been very impressed with the best interest assessors that we've met up and down the country, who seem to be very knowledgeable, they seem to be very assertive, and they seem to take a lot of professional value from their work. We think that role needs greater recognition and greater legal status, so we've built on that in our new scheme. In effect, the new Approved Mental Capacity Professional would be very similar to the best interests assessor. But the new professional would have a lot more professional responsibility. So if you think about how the DoLS work at the moment, everything is outlined in detail. Every single decision is specified on the face of the statute, and it tries to second guess what everyone's going to think. That's not the case under this scheme. The assumption is reversed. We think that professionals can take responsibility for these sorts of decisions. And it's not the job of legislation to try and second guess you, to try and make sure you're making a certain decision. We think that professionals can make those decisions. So the AMCP would be responsible for the assessment. As I mentioned before, they wouldn't need to do it themselves. We would expect that as professionals, the AMCP could identify cases that are serious and would benefit from the independent assessment of an AMCP. They don't have to do it in every single case. The AMCP, again, would be responsible in a long-arm sense for monitoring the person's care and support and just making sure things are ticking over okay. So they don't need to take on the case as the allocated worker. We hope that in most cases where a person is subject to restrictive care, there may already be someone involved and the things can be left. So good social work and nursing care practice would continue. But in some cases, they may need to step in, particularly when there are problems around. So legally, the AMCP would be in a very similar position to the approved mental health professional under the Mental Health Act. The AMCP would be an individual decision maker acting on behalf of the local authority, but the AMCP has ultimate responsibility for decisions which are made. And we think that's a very important aspect of the new scheme, that it doesn't have to go through a convoluted oversight route via the local authority. This is all about an individual professional approving a care plan, which we hope fits into existing good practice. And to further recognise the enhanced status of the BIA, or Approved Mental Capacity Professional, we're suggesting that some degree of regulatory apparatus could be put in place. So, for example, the HCPC could start to set standards for the training and knowledge required of AMCPs, and the professional status could also be indicated on the relevant professional register. So deprivations of liberty are still part of the scheme. They will still be necessary under protective care, And they would still need to be authorised, because that's what the European Convention requires. So the best interest assessor, or the AMCP, would need to be very vigilant about the possibility of a deprivation of liberty of someone who's subject to restrictive care and treatment. If it looks like the person is being deprived of liberty or will be deprived of liberty, the AMCP would need to authorise that first and specify that first on the person's care plan. That would include being satisfied that sufficient medical expertise had been provided, because that's required under the European Convention. Now, that doesn't mean a Section 12 doctor in every single case. It doesn't mean a specialist psychiatrist in every single case. We think that the AMCP should be able to decide which medical professional should provide the evidence. So should it be the person's GP? Should it be their consultant? Do they need to buy in a Section 12 approved doctor to provide some level of independence? In some cases, we think a psychologist may well be appropriate. We would leave that down to professional discretion as to what level of medical expertise is provided. It should sit on the individual circumstances of the case and not be required in every single case. But if the AMCP is satisfied that the person needs to be deprived of liberty in their best interests, and that all the evidence is there, then they can authorise that on the basis of the care plan. Now, it's also important for me to mention that this aspect of our scheme could apply also to people living in domestic and family settings, so people who aren't living in some form of institutional supported living or something like that. So if someone is living at home in very basic terms and is being deprived of their liberty, and Article 5 applies, then an AMCP could authorise that deprivation of liberty on the basis of that person's care plan. They would not need to go to the Court of Protection or the new tribunal in every single case. It could be authorised quite swiftly through a care plan. Now, we're anticipating that this will be a rather contentious aspect of the scheme, because it doesn't feel right to start intruding on a person's private and family life. Nonetheless, Article 5 can apply in those sorts of settings. And on that basis, I think it's right that we start from the assumption that we try to support best practice in those sorts of settings. So we think building the safeguards around a care plan rather than a court of protection application is the right thing to do. But as with all of our proposals, we're very happy to take views to the contrary. We also have a bespoke system for hospital and palliative care. So this is slightly different because it's organised much more around the concept of deprivation of liberty. This is a really streamlined process. It doesn't provide the additional early intervention types of safeguards that we've proposed for other settings. It's much sharper, much focused on authorising a deprivation of liberty, and that's because of the nature of these settings and the sort of short-term nature of admissions to these settings. So essentially, someone in a hospital, for example, can be deprived of liberty for up to 28 days if, first of all, a clinician has decided that they lack capacity and it's necessary, in order to receive their care and treatment in their best interest, that they be deprived of their liberty. So the clinician would need to undergo an assessment, confirm that, and send that off to the hospital managers. The hospital managers would then need to get a second medical opinion or a second opinion to authorise the deprivation of liberty. On the basis of that, the person could be deprived of liberty for up to 28 days in that hospital palliative care setting. During those 28 days, the person must be allocated a responsible clinician, and by responsible clinician, I don't mean the one under the Mental Health Act. I mean a clinician who's responsible for that person's care in a very general sense. They also get a care and treatment plan, which is constructed with the agreement of the families and carers and friends. They also get rights to advocacy and the ability to appeal against their detention to the hospital managers, in which case the hospital managers could hold a hearing if they so wished. and also right to appeal to the new tribunal against their deprivation of liberty. If the clinicians feel that the deprivation of liberty needs to be extended beyond those 28 days, the agreement of an AMCP would be required, so there would be a greater level of independence to authorise any deprivation of liberty beyond those 28 days. So it's a much more sharper and streamlined system in hospitals and palliative care. Finally, we have the very thorny issue of the interface between our scheme and the Mental Health Act. And if you've read the relevant chapter, you'd have felt my pain in looking at this area. It's a complete nightmare. I'm sure I don't need to tell you that. We went through a lot of different options to try and clarify things. You know, we thought about trying to codify some elements of the common law, getting rid of some of the weird case law you have in this area, you know, the but-for test and that sort of thing. But everything seemed to become very sort of uncertain and didn't really work. What we're putting forward at consultation is quite a simple system whereby we think that these people, generally speaking, have been admitted to hospital. They need medical treatment for their mental disorder. Therefore, we're looking to the Mental Health Act to do the work in this area. So in effect, if a person who lacks capacity needs to be admitted to hospital for mental disorder, we would extend the Mental Health Act to allow for a new admission process where that person needs to be deprived of liberty. So as long as they're not objecting to their care and treatment, they go in under the Mental Health Act. That would need to be assessed and signed off, and then if they're admitted, they would be provided with safeguards, which in very broad terms are similar to the sorts of safeguards a person who lacks capacity gets when they're placed under a community treatment order. So they get things like rights to a care plan, an independent advocate, a second medical opinion, and they can go to the mental health tribunal to appeal against their care and treatment. So our solution to the interface is to draw a line in the sand to say that these people are probably best dealt with under the Mental Health Act, where clinicians are probably more familiar with that piece of legislation, and our new scheme could not be used to authorise the admission, the hospital admission, of people who lack capacity, who require treatment for their mental disorder. Great, so I've just got a couple, no, I haven't got a couple of minutes left, I've got a minute left. Well, I'll just tantalise you with lots of other goodies from the consultation paper, which you may or may not be interested in. 16 and 17-year-olds, we've looked very carefully at the position of 16 and 17-year-olds who are included under the Mental Capacity Act, but for some reason not under DoLS. We don't see any good reason why they should be excluded from those safeguards, and why such cases should have to go to the High Court for authorisation. So we're suggesting that 16 and 17-year-olds who lack capacity would be brought in under our system. And we're also querying the validity of the role of the zone of parental responsibility in relation to such people. I'd be very interested if any of you have experience of that. Supported decision-making. So this is the idea that if you provide someone with additional support where they're on the borderline between having capacity and lacking capacity, you may be able to enable them to make a decision. So we're putting forward a scheme which would allow a legal way of authorising that, to allow an individual disabled person to appoint a supporter to help them make decisions jointly. We're also suggesting reform of the best interest checklist under the Mental Capacity Act to try and heighten the importance that's given to a person's wishes and feelings. Consolidation of advocacy. So I get mixed up with all the different advocates you get. I'm in this field, the IMCAs, IMHAs. We're suggesting that you could achieve cost efficiencies by stripping that down and providing the same basic right to advocacy without all the different intricacies, and allowing advocacy just to flourish under a single legal banner. The role of the RPR would continue. We're also suggesting reform of the coroner's legislation, which I know some of you will be very interested in here, but I won't waste your time trying to explain that here. We're also looking at advanced decision making. Neil talked about that a little bit, about entry to palliative care. One of the questions we look at in the consultation paper is whether that could be codified in the law. So whether the new statute could actually confirm that you can use advanced consent when someone is going into care and treatment. And finally, governance and oversight. So someone mentioned earlier difficulties with the role of the CQC and other regulators. That will continue to be a problem under our new scheme because we don't imagine that we would be able to create a new regulator, for instance. The DoLS regulators are the regulators on the ground, so we need to think about smarter ways of regulating deprivations of liberty. And we've looked to other jurisdictions that allow things like an expansion of the scheme of lay visitors, for example, or we've also discussed the use of advocacy as a sort of signpost, waving a flag when things are going wrong. So we're looking at governance in the round in that respect. So that's it in a nutshell. That's your new protective care scheme. As I say, it's up for grabs. Hopefully there's lots of things there you agree with. I'm sure there are things there you disagree with. And maybe there are a number of other things that you think, and you want to go away and think about, which is equally fine. But I'm very interested in your questions.